DW1 and DW2 were cross-examined and discharged. The defendant did not re-examine their witnesses. The court adjourned for adoption of final written addresses. The claimant filed its final written address on the 7th of June, 2024. The defendants filed their reply on points of law on the 19th of June, and all arguments are in the body of the judgment. So I'll move straight to the decision of the court.
As the court pleases.
Okay, just a minute.
As the court pleases.
Hold on. The decision of the court. Before going into the merits of the case, during trial, the learned defense counsel raised an objection to the admissibility of the document admitted and marked as Exhibit C8. According to the defense counsel, Exhibit C8 was inadmissible, being a photocopy of the original. C8 is relevant and was pleaded, so it is admissible even given that it was tendered to contradict the testimonies like evidence of deed from the defendant to the claimant's counsel dated 23rd November 2023, signed by one Olajumoke Odudim. It was pleaded in paragraph 16 of the statement of defense, and it was referred to by DW1 and DW2 in their respective written statements on oath. However, though pleaded and front-loaded by the defense, the same facts of the case as pleaded by parties, the court in aiding it to resolve the matters in dispute between the parties. Paragraph 2, for instance, disclosed that a period of 3 months was communicated to the claimant by Lisa, the then HR, and Fikayo Ogunfoyo, country director, DW1. Paragraph 4 stated that claimant accepted the extension of probation period on same pre-confirmation salary. In addition, the defendant also reverberated some facts that it raised in its defense. The rules of evidence may have been faulted because foundation of the document counsel showed DW1 a photocopy. DW1 confirmed he is aware of the letter, that it emanated from the defendant, and it was a response to Exhibit C6. No foundation was laid on the whereabouts of the original. In law, what governs the admissibility of evidence at trial is relevant. See Abubakar versus Subut, citation provided. Documentary evidence is admitted when it satisfies 3 major requirements, namely, is the evidence pleaded, is it relevant, and is it admissible? See, it was not pleaded by the claimant and secondary evidence enumerated in Section 89 of the Evidence Act as amended. The fact that the claimant did not directly state in his pleadings that he found and would be relying on the documents constituting Exhibit C8 does not in itself mean that the said document was not pleaded by him. Once there are facts in his pleadings that mentions or alludes to such document or to its existence, it satisfies the requirement of the document being pleaded. See MMA Incorporated versus NMA 2012 18 Nigerian Weekly Report Part 1338506, where Nweze JSC in Omisore versus Arugbeshela, citation provided, said evidence obtained in cross-examination on matters that are pleaded, that is, on matters on which issues are joined, is admissible. The Supreme Court has equally held that the judge has a right to exhibit. See Agba Homovo versus Eduyegbe, citations all provided. In O2 versus Intogwile, citation provided at page 56. The Court of Appeal held that once a document has been tendered as an exhibit, the court has a right and a duty To refer, this court noted much earlier that Exhibit C8 is relevant in resolving facts in issue between the parties. It was pleaded and formulated by the defendant, even alluded to by the claimant in his pleadings. So in the interest of justice and by the powers conferred on the court by virtue of Section 12, Sub 2B of the National Industrial Court Act and Order 5, Rule 6, Sub 2B of the NICN Civil Procedure Rules 2017, which permits the court to depart from the provisions of the Evidence Act in the interest of justice and admit documents at trial. This court is of the considered view that the interest of justice requires such departure in relation to the admissibility of Exhibit C8. See Adegboye versus UBA PLC, citations provided. Accordingly, the learned defense counsel's objection to the admissibility of Exhibit C8 is hereby overruled, and the said document remains admitted in evidence and marked as Exhibit C8 ISO room. The court will subsequently determine what weight to attach to the said document. It is on record that the claimant seeks, as part of his reliefs, declaratory reliefs, which require the claimant to succeed on the strength of his case and not the absence of a defense or the weakness of the defense to the suit. See Adamu retired versus Nigerian Air Force citation provided. Relief 1 is for a declaration that the termination of the claimant's employment was unjust, unlawful, and against international best practices. It is tried that a person on probation can justifiably be categorized as an employee. Generally, probation is a testing of a person's ability or behavior to find out if he or she is suitable. It is a suspension of a final appointment to an office until a person temporarily appointed has by his conduct proved himself to be fit to fill it. See Total versus Onoha citation provided. In other words, an unconfirmed employee is entitled to employment rights. In the Zimbabwean case of Kangwari versus CBZ, citation provided, it was held that the courts require employers to justify the dismissal of probationary employees in much the same way as they are required to do in the case of any other employee, with the possible proviso that the court may be disposed to accept in the case of less compelling than they will require in the case of long-standing employees before dismissal is embarked upon. The general principle is that the employees should be timelessly informed of his deficiency, be told how to rectify it, and be given a reasonable opportunity to improve before any action is taken against him. The claimant alluded that no evidence was placed before the court to show the yardstick for assessing the claimant's performance that led to his termination. During cross-examination, DW1 was asked, and I quote, "In your termination letter, Exhibit C4, you spoke of quality standard. Now, is the quality standard same as job description?" He answered, and I quote, "It is part of the quality standard." He was also asked, "Was there any code of conduct that spells out other quality standard?" He answered, "No." It is therefore typical for the termination to be assessed on a non-existent or a subject was terminated other than he did not meet expectation. Even when he asked his boss if there were concerns or dissatisfaction with his work, he was told in Exhibit C3, and I quote, "There is nothing from me so far because the migration we planned on September the 1st delayed and it will be November the 1st. This is for Ghana. There are no dissatisfactions from me because there are simply not much work for you now." End of quotation. He was not informed of his deficiency. He was just invited to a one-on-one meeting and told to work harder. The areas of improvements were left vague. On the issue of the quality standard referred to in the termination letter, DW1 stated under cross-examination that there was no code of conduct to spell out quality standard, nor was there an organogram in the defendant stating hierarchy, and he was made to believe that as head of customer care West Africa, he was to receive instructions from the global head of customer support and not a country manager. During the pendency of his employment, his performance was never reviewed, neither was there any complaint from any member of the defendant. It would have been a different ball game if the defendant in Exhibit C4, that's the termination letter, had accused the claimant of failing to discharge the rules spelled out in Exhibit C1 as his job description. So to state that CW1 did not meet the desired quality standard, which was never spelled out nor produced before the court, is inviting the court to embark on a voyage of discovery which the law frowns out. This court is convinced, based on the facts presented, that the defendant can validly terminate the employment during probation as clearly stated in the termination clause in Exhibit 1. But since his termination was preceded by a reason, the defendant is expected to adduce evidence on the plausibility of the reason vis-a-vis the term of the employment contract or the code of conduct binding the parties. This element was not satisfactorily established. Therefore, this court declares that the termination was unjust and unlawful and against international best practice. I so hold. Learned Claimant Counsel raised the question whether 22Bet has the locus to offer the claimant employment. In paragraph 3 of the statement of material facts, the claimant stated that he was served with employment contract from both the defendant and 22Bet on the 26th day of June 2023. In his witness statement on oath, paragraph 2, he stated that the defendant has a subsidiary organization which primarily is into sport betting known as 22Bet. Exhibit C2 is a job offer from 22Bet, offering the same position as mentioned in the Exhibit C1, and I quote, head of customer support for West Africa. As stated in his paper, Labor Adjudication in Nigeria, PhD, the Honorable President of the Nigerian Industrial Court of Nigeria, stated the reality of the world of work has gone far beyond the binary relationships hitherto known of employment relationships. The injunction of the ILO that the triangular employment relationship is a disguised or objectively ambiguous employment relationship, which is meant to either mask the identity of the employer or mask the form in which the relationship is established. From the totality of the claimant's pleadings and evidence, it is clear that the claimant was in the know that 22Bet was an agent of a disclosed principle. In this case, the defendant, see Mbata versus Amanzi, citation provided, paragraphs A to C. The claimant pleaded that 22Bet was a subsidiary to the defendant and entered into a contract of employment with him as the defendant, only to turn around in his address to contend that 22Bet is not a juristic person and lacks the locus to enter into contracts. Counsel's address, no matter how articulate or brilliant, cannot take the place. Citation provided. Clearly, there is evidence on 78 of Kama 2020 to be applicable in the instant case. The claimant must be required to prove that 22Bet is a foreign company and proceed further to separate its acts within Nigeria from those discharged or performed outside Nigeria, to make those undertaken in Nigeria qualify as void. This has not been done and is not the case. A careful examination of Exhibit C1 and Exhibit C2 revealed that their contents are essentially similar, such that even where Exhibit 2 is set aside for emanating from a non-juristic entity, the claimant is still bound by Exhibit C1. Given the fact that the claimant knew beyond doubt in relating with officials of 22Bet that he was in an employment relationship with the defendant, he invariably knew on miscourt that the claimant had an employment contract both from the defendant and 22Bet, dated 22nd day of June 2023. It was signed by a director of the defendant, Pavel Kovlovsky, via email. He was appointed as the head of customer support for West Africa, both for the defendant and 22Bet. Both parties tendered both documents, that is Exhibit C1 and Exhibit C2. Facts not disputed need no further proof. An admission that is clear and unequivocal is binding on the maker, who cannot be held to change the same to suit his new case. See Al-Hassan citation provided. There is C1 and Exhibit C2. It was pleaded, but denied that the author of Exhibit C2, Lisa, was not authorized to issue it because she was just a technical consultant to the defendant. Interestingly, in Exhibit C8, which was a reply to the defendant, which was the reply that Lisa was the head of HR, revealed, and I quote, she had communicated a period of 3 months to the claimant as his probation period, end of quotation. However, the court has carefully read Exhibit C2, and there is no mention. Exhibit C2 was tendered into the two-bed as an agent of a disclosed principal, which also makes it a binding contract on the claimant, as it would be the defendant that would be liable for any breach by 22-bed while the latter acts as its agent. CGTB versus Noble, citation provided at page 413, paragraphs A to B. For this reason, the learned claimant counsel submission that 22-bed be and therefore lacks locus to enter into. The claimant raised the question for determination whether the extension of the probation period was unlawful and unjust, and sought a declaration that the extension was illegal and unjust. Probation is a precursor to confirmation. The claimant never pleaded that his employment was confirmed. Paragraph 3 of the claimant's witness statement extended. It's important to note that the offer letter from 22-bet under the column for salary provided that, and I quote, $1,700 net, in bracket, the salary can be increased later, can be increased after the probation period based on the performance, end of quotation. Exhibit C2 did not extend probation period. It stated, dear Stephen, as we agree, the salary will be $2,000. And after the 3 months, please confirm the changes, end of quotation. What the duration of the probation to be 3 months after $1,700 to $2,000. So back to the question, at what point was the probation period extended? Was it extended at the one-on-one meeting with DW2? Was it extended at the one-on-one meeting with CW1? Was the increase or extension reduced to writing? The claimant, I think Exhibit C3 answers this question. Unilateral alteration of the fundamental terms of contract is forbidden under the modern jurisprudence of employment law in Nigeria, as ushered in by Section 254C, sub 1F to H of the Constitution, and Section 5 and 15 of the National Industrial Court Act. Even before the Third Alteration Act, Section 7, sub 1H, and Section 2 and sub 2A and B of the Labour Act, though permitted the employer ostensibly to unilaterally alter the fundamental terms of contract, but nonetheless insisted within 1 month thereof. I think it goes beyond argument that even though imperfectly, the intent of Section 7, sub 1H and sub 2A and B of the Labour Act is to enable the worker or employee to size up the situation and make up his mind whether or not to accept the unilateral alteration. In effect, though imperfectly, the law in Nigeria, even before the Third Alteration Act, was that unilateral alteration of the fundamental terms of employment contract was illegal. Unilateral alteration of fundamental terms of contract has always been illegal. In interpreting Section 7, sub 2 of the Labour Act, such a major change in the status of the employment relationship had to be formally communicated to the employee. Besides, when a thing is said to be extended, then it means it had a period tied to its existence. In paragraph 6 of the statement of defense, the claimant stated that, and I quote, he, referring to the claimant, was informed by Fikayo Ogunfoye, DW1, on the 10th of October 2023 of his performance falling below the company standard, and that his probation period, even though it might be extended, he had to work harder, end of quotation. The evidence on the alleged extension of the claimant's probationary period is shaky and appears improbable. The claimant was employed on the 26th day of June 2023 and said under cross-examination that my understanding is that my salary will be increased after 3 months and my probation would be completed after they say 3 months, end of quote. As at 10th of October 2023, when the one-on-one meeting took place, the claimant had spent well above 3 months and a week in the defendant's employment. Exhibit C1 and Exhibit C2 provide for a 3-month probationary period, thus giving the impression of a deemed confirmation as argued by learned claimant counsel. Though it appears that the defense stance is that it needed time to appraise the claimant's performance during the probationary period so they delay. Employment would not be confirmed in Exhibit C3. Claimant reached out to Vladimir on the 11th of October 2023, who was his boss, to confirm if there are, and I quote, if there are concerns or dissatisfaction with his work as head of customer support for West Africa, and he got a reply to the negative. It is a law that documentary evidence is the hanger on which oral evidence rests, and no oral evidence can be permitted to vary the contents of a document. See Schwab versus Mwazo and Mwafo versus EFCC citations all provide formal in writing to the claimant that no reasons, neither was it certain of the Labour Act provides for the written particulars that should be included in the terms of employment. Section 7 sub 1C provides for the nature of the employment, while Section 7 sub 2 places a responsibility on the employer. So man was kept in the dark or doubt about his confirmation status was not just fair or just is marked unfair labor practice. It is obvious that the extension of the claimant seeks in relief 3 and 4 orders to restore and confirm his employment. As stated earlier, the defendant terminated the employment Exhibit C4 based on low performance, but failed to provide the claimant with the quality or standard code. Neither was any evidence tendered before this court, which makes the termination unlawful. The claimant is basically asking for reinstatement. Learned Claimant Counsel, in pushing for this remedy, forgot the legal status of the employment in issue, that it is not a statutory employment, but that governed by common law. Although the relief of reinstatement is not exclusive to statutory employment, unlike statutory employment, it is not automatically awarded in employment governed by common law its application. I find that the plea entitlement was made available by the claimant. While common law principles seem to resist reinstatement in master-servant relationship, our courts have ordered reinstatement when it is shown that the termination of the servant's employment was done as a victim of trade union activities, when the law does not support the circumstance and procedure the employee services was terminated, and when the employment enjoys statutory flavor. See Management of Dangote Industries Limited versus National Union of Food, Beverage and Tobacco Employees. See EcoBank versus Bello, unrepeated judgment delivered by Honorable Justice Sanusi Kado in suit by NICN APJ/144-2020, and also see University of Lagos versus Aiguru, citations all provided. By the pleadings and the evidence adduced by the claimant and viewed against the law as stated, it is my determination that the termination of the claimant's employment is only wrongful. I so find and hold. In a case for wrongful termination, claimant is a claim for damages, not reinstatement. For each wrongful act, an employer who terminates the contract with its employee is in an unlawful manner will be liable to damages for the breach of contract. See Obani versus UBN PLC, citation provided. So then on to the court, fostering a willing employee on an unwilling employer. The Supreme Court made the point very clear in Agu versus Julius Berger, citations provided. A court cannot foist or impose an employee on an unwilling employer. The remedy is always an award of damages where the termination is held to be wrongful, but certainly not a declaration that the termination is null and void. This is why there cannot be a relief for specific performance like an order for a statement. See ZD versus RSCSC 2007, 3 Nigeria Weekly Law Report, Part 10, 2255 form. It will amount to an undue judicial interference in labor and employment relations. This court will decline making an order 3 fails and 4 cannot stand on any foundation as it fails as well, and I hereby decline to make the order as prayed. I so would. Relief 5 is an order to pay arrears of accrued sum meant to be paid by the defendant upon confirmation. Relief 6 for payment of salary of $2,000 for month of December 2023 till the termination of the case. As earlier stated, Relief 4 failed, and so Relief 5 has no foundation to stand. It is hereby declared that the termination of the 20th of November 2023 is unjust, unlawful, and against international practices. The extension of the probation period was unjust and unlawful. The court finds that the termination of the claimant's employment was wrongful, but there was no claim for damages in this suit, and so the court cannot award what it is not claimed. See, what cannot be found to be a Father Christmas and cannot grant what it was not asked for by the litigant. See David John Chia and another versus Philip Bembe and others, citations provided, where it was held that the court is no Father Christmas and never grants orders not prayed for. Therefore, Reliefs 3 to 6 all fail. Cost of litigation in the sum of 500,000 naira is to be paid by the defendant to the claimant within 30 days. Thereafter, simple interest at the rate of 10% per annum will be paid till the judgment debt is liquidated. Judgment is hereby entered accordingly. Signed, Honorable Justice Joyce A. Damachi. So this is the judgment of the court.
As the court pleases.
As the court pleases, we are most obliged. And we thank my well-considered judgment.
My Lord, on our part, we're also grateful for the well-considered judgment, and we pray that good Lord will continue to increase the court. We are most grateful.
I'm most grateful.
Okay. All right. Thank you.
Hello, hello, man.
As a registrar. Registrar.
I think she's still online.
But she has muted.
Ah. Wow.
Okay, I think we'll just have to contact her so that we can even get
the audio and even the hard copy.
Yeah, because there were so many gaps.
Gaps in what sense?
No, I mean there were so many gaps at the point where she was reeling out the orders of the court. Yes, it was so bad. It was so bad.
I noticed she was recording anyway. I noticed she was recording. So I just
hope the recording is clear too.
That's another thing.
That's another thing. We could download the judgment of the court from NIC website, though it's not certified. When the court resumes, I don't know if she told you that much yesterday, but when the court resumes, I asked so much questions because someone needs to know how to guide going forward. So he said the court has not resumed because it's on vacation. I think my lord is still in Abuja.
Oh, okay, no wonder.
So I think if she can guide us as to how to
download it and then
from the website, first of all, before someone gets certified true copy.
Okay.
Someone have to contact her. She has not even come back. She has not unmuted.
Oh.
Okay then. We'll just have to leave them. We'll reconvene. No problem. Right. So whatever happens, we'll reach out to you.
Okay. I'll be expecting the judgment song.
No problem. We'll do a letter to that. We'll communicate to our clients. Very well.
Yeah.
Yes.